those who are the IPR students, they know patent is a very lucrative property, and generally one concept in the patent is that patents are never valid. At least they are not valid till they are contested in the court of law. Otherwise, the validity of the patent is a mere presumption, right? It remains a presumption. You have got a patent, it is a presumption that it is a valid. Somebody tomorrow will come and file a opposition and will try to get it invalidated, right? It may happen in the patent or in other intellectual property also, but here the chances of invalidations are very high on different grounds. On say a work being not novel, on the ground of non-obviousness not existing in the particular work, or it is something which is erroneously granted to a non-inventor who is not the true and the first inventor of the work, but he has used up somebody else's work and have got it patented. So on such grounds, on inherency, etc., sir will tell you a lot of other grounds also. But on these grounds, patents are invalidated. So he is the one who, as an expert, goes for the invalidation of the patents. And among other things, in the patent prosecution, which he does, which you will know through him. So we welcome you, sir, here in Faculty of Law. It is definitely our it is definitely our fortune that you kindly agreed. In fact, he himself volunteered that I would like to come and interact with the students. So we are blessed that such a person, such a noble gesture, you on your own volunteered and funded from US and then to come amongst us and to speak with us. We wholeheartedly thank you, sir, on behalf of Law Center 2 and on behalf of the Law Center 2 Contemporary Law League. Let me tell you, most of these students are members of the EMC, that is Contemporary Law League at Law Center 2. And majority of them are first year students. This is what I believe in. Some LLM students are there, some Padi colleagues are also attending. Most of them are first years. कितने लोगों ने IPR पढ़ा है अभी? Raise your hands. Many. We have good number. Okay, over to you, sir. Thank you.
That was not the reason why I raised my hand. Good afternoon.
Good afternoon.
Actually, it is 4:30 in the morning in US. So it should be in the morning. It's early morning. I am not a lawyer. He made it very clearly. So I am in an uncharted territory in a way. There is a perception in India which we then correct the law. Now, I have a Center for Excellence in IP and law. Through that, we present courses on IPR, all the domains of IPR, and not only just patents, but also what to do with the patent, what not to do with the patent, whether we should patent or not, strategies, protection, preservation, prosecution, all of that. So a non-threatening way. So in a non-threatening way, because two places nobody wants to go. One is to step into a medical hospital as a patient, and second is to step into a law office to engage a lawyer. So nobody wants to do that. So whenever we talk about IP, objection is IP is law. It is not totally correct. It is partially correct. So we did a survey a few years ago in more than 14 disciplines in India, with about 1,500 to 1,600 professionals who are not law professionals. And we asked them, what is your perception of IP or IPR actually? Oh, that is law. That is law stuff. When you start to realize what exactly IPR is, law has a major role to play, that is correct. But the key question is, let's start with a non-threatening basic understanding of what IPR is. IPR is intellectual property intellectual property rights. Now for that, in order to get the rights, you need property. You cannot get a registration for your house without having a house. You cannot get a registration for your bike without having a bike. Okay. So in order to get exclusive rights for 20 years from the day you file an application for patent, in order to do that, you have to have something to claim as your property. And that property has to be intellectual property. What is exactly the difference between intelligence and intellectual? Intelligence is when you complete a program. Okay? And I follow this very easily. When you complete a program of 4 years, that is BSc, pharmacy, medicine, engineering, whatever, the graduation speaker or convocation speaker tells you for the first 13 minutes of the 15-minute talk, strokes your ego. 4 years हमने hard work किया, now we are passed all those courses here, got all your information, now you are ready to go into the field to work. We are waiting for you. And in the last 2 minutes, the bomb is explodes. But your learning will start now. 4 years क्या कहते हैं हमारी? After 4 years, now you are telling me that well, I'll give you a degree, but your learning will start now. So, what is this intellectual property? Difference between intelligence and intellectual. First is whenever you complete a program, you become intelligent. That's it. When you apply your information that you have learned in order to get something, that get is known as create something. That is intellectual. I have a 4-wheeler with 4 wheels, 1 engine, 1 steering wheel, 1 driver's seat, and a ceiling. For my vehicle which takes me from point A to point B. It takes me from point A to point B in 0 to 60 miles an hour in 10 minutes. There you have. Now, with all my automobile engineering, my physics, my mathematics, my science and motion that we all have learned in intelligent part 4 years, I apply it to convert it into a 3-wheeler, doing the same thing. 3-wheeler, 1 engine, 1 steering wheel, 1 driver's seat, 1 seat. But this 3-wheeler goes from point A to point B at same speed. So I have gone from 4 to 3. So I applied whatever I have known to my intelligence to create this. So that is innovation. If from a 4-wheeler to 3-wheeler, the 3-wheeler was never existing before, so that is normal. First time ever. So now I have created something for which I need to gain rights, exclusive rights on that. That is what we want to do now. I have created this 4-wheeler to 3-wheeler, so-called innovative way, first time ever, and I want to gain the rights to protect that so-called invention. Today we don't know what is implementing, we will come to that in a few minutes. For that there is a process. We have to first show that well, everything that we know on the four-wheeler we had, what I knew from science we have put together, and then we have created a three-wheeler and I have provided examples to show. That this three-wheeler is doing this, which is never done before, and I have applied innovative ideas. That process is what you folks come into the picture, where I have created something and I need to translate it into a so-called patent or a claim which I need to get it granted or allowed, granted by Indian Patent Office or allowed by US Patent Office. There is a difference. For that, it has to be legally processed. It legally has to be there. Why? Because the examination is going to happen on a equality basis. You prepare an application for this four-wheeler to three-wheeler, put it into a format which is for the patent office, which is legally okay, which is cleared by a patent agent or a patent lawyer, so and so, these professionals, and it is submitted to patent office. Now the patent office, that application goes to a patent examiner. So far so good. The examiner is not a subject matter expert, which is now different than when you write a publication manuscript. It goes to a publisher, you send it to a publisher. The publisher sends it to a reviewer who is a subject matter expert. But here, the application goes worldwide. Any patent office, in fact, it goes to an examiner. That examiner has just qualified himself or herself through a patent examination board. So then you become a examiner, patent examiner, or a patent agent in India. So now what happens is, you have this automobile engineering work that you want, that you have created in your hand, four-wheeler to three-wheeler, goes to a home science major individual who is a patent agent or examiner. Now you tell me, will that examiner be able to appreciate what you have done and grant you or allow you these rights by giving you a patent? That can only happen if I have criteria which are common to all patent offices worldwide. And that's where WIPO comes into the picture. In 1995, December 5th, India became a signatory of WIPO and WTO, which basically meant that we have to change our laws to meet the legal requirements of granting a patent, protecting a patent, litigation, arbitration, so on, at par with the world where those countries who are part of the WIPO. So now we are at par. Which another important outcome of that is all Indian patents will be honored in those countries who are members of WIPO and WTO, and we also should honor their patents in India. These patents mostly are the most, I guess, they are attractive ones, or so to speak, where the value of your IPR is high, is a product patent. So if I have created this three-wheeler, that is a product. So now I will own the rights. But my first headache is to get a patent on this three-wheeler, for which the criteria have to be as per WIPO, which has to be adopted by the country directly meeting the patent office of that country or Indian patent office. So now the question is, what are those criteria? I can file that application in US, I can file it in Australia, I can file it in Europe, I can file it in India because they are all members of the country. Okay. Now the question arises is, I file an application in Indian patent office and it gets rejected. The same application is filed after rejection in US patent office and gets accepted. Question is why? Should not happen that way because both are members of WIPO, both are expected to have the same criteria. Then it doesn't matter whether a home science major subject matter expert is a patent examiner or a physicist is a patent examiner or a chemist is a patent examiner or a lawyer is a patent examiner who is not practicing IPR or family. That is fine if the criteria are the same. But unfortunately, well, first let us see how many criteria are there. There are 7 criteria that we have to abide with. All of them, not 5 of the 7, 6 of the 7, minimum 3 have to be. No, all 7. This product that I have created has to meet all 7 criteria. What are those criteria? Number 1 is novelty. First time. Now we are talking about law. I can give you the CFR numbers of USC, which is the United States Code. In India it is IMC. This is now your neck of the woods. First is novelty. Nobody has done this before. I have to prove it. Number 2 is innovation. What is already known, I have taken advantage of that and modified it to get to knowledge. As this automobile engineering background, math background, physics background, I put into picture and made a 3-wheeler vehicle which goes from A to B at that speed. Innovation is number 2. Number 3, which is the most difficult, is non-obviousness. What is non-obviousness? Non-obviousness is basically, in very simple terms, the elements of your invention. What are the elements of your invention? 3 wheels, along with 1 engine, along with 1 steering wheel, along with 1 driver's seat, and a ceiling which function as a vehicle going from point A to point B at that speed 0 to 60 miles an hour in 10 minutes. Those are your 7 elements. Okay? Yeah, so far okay? Then I ask someone, can you tell me the 7 elements that we talked about? Wheels, engine, steering wheel, driver's seat, ceiling. That vehicle goes from point A to point B. That's 0 to 60, 10 minutes. Right? Now, these 6 or 7 elements of your invention, I will check in the literature which I provide in Indian Patent Office as an information disclosure statement. In US Patent Office, you file a prior art search and analysis. Same thing, literally the same thing. See, just a different pattern. क्योंकि हम some दूसरों का सब करेंगे लेकिन हमारा पैटर्न अलग होगा. Because we are unique. And वो छोड़ना है. That is a little bit sidebar. So this information disclosure system statement that we provide, we have to show that prior literature में कोई vehicles है जिसमें 3 wheelers है, नहीं है, 4 wheeler है, हाँ है. Go from point A to point B, हाँ है. Speed mentioned है, driver's seat है, engine है. So if all these 7 elements are in prior art but not in one piece of prior art in public domain. एक publication में, एक previous patent में, एक report में नहीं है. So they are scattered in your prior art. Literature structure प्रत्येक. So let's say you have 10 pieces of literature in which these are scattered. So a person of ordinary skill in the art should be able to get all these 6 pieces of elements, the 6 elements, vehicle, etc. From these 7 pieces of prior art, person of ordinary skill in the art should be able to pull them together and come up with a 3-wheeler as an option. With the major caveat is that person of ordinary skill in the art should be motivated to do that. So motivation कैसे improve करोगे? That is another totally different aspect. So person of ordinary skill in art is able to put these all 7 pieces of elements in your invention, come up with a 3-wheeler vehicle, then that invention is obvious. So it cannot be granted back. So I have to prove that it is not obvious for that person. And any number of grounds. So that is your third most difficult requirement. Fourth is, if all those 7 elements in the prior literature were available in one single document, numero uno, only एक public domain में अगर एक पेपर है, एक प्रीवियस पैटेंट है, एक प्रीवियस रिपोर्ट है पब्लिक डोमेन में, कोई भी कंट्री में कोई भी लैंग्वेज में, if I am able to produce that and provide that as code is available, then person of ordinary skill all of that is anticipated. सातों elements है ये, so it is not eligible for granting a patent. That is known as fourth requirement is anticipation. Fifth is enablement. आपने जो 4 wheels से 3 wheels का बनाया and you provided all the information on how it was done with examples in your academic application. A person of ordinary skill in art should be able to practice that. अगर आपने जो examples दिए हैं, if I want to see whether your invention is I am able to reproduce it, then yes, that is enablement. Provided complete information, easy to understand, easy to follow with examples which are all known as specifications. अगर वो हो गया तो it is enabled, so you will get a patent claim because it has to be enabled. Not that you practice it, because if you practice that, then you will be copying somebody else. तो जो हमारा record होता है India. So that is the fifth requirement is enablement. There is a cultural problem in India. Funding agencies for research to create new language in India, they dissuade researchers from filing the patent because सब दिखाना पड़ेगा, सब बोलना पड़ेगा, तो somebody else will copy. So नहीं आप करते रहो. It is like 2 women exchanging a recipe and they prepare that recipe in totally different formulas. तो हमने इसने बोला नहीं कई बार ऐसा करना है, वो एक आइटम फिर कर वो नहीं करना चाहिए. Actually, in US, if it is found that on purpose you have withheld information either in your prior art analysis, information disclosure statement or enablement, then you are liable for punitive damages. So much so that you will be barred from applying having your name put as an inventor on any application for life. 2 more requirements and then I will begin speaking. So पहला क्या था? Novelty. Second one was innovation. Third one was obviousness. Fourth one was anticipation. Fifth one was enablement. Sixth one is, I have provided all the information in my application and my claim also. तो one of the element और हमारे पास 7 elements है इसलिए even one element I have not provided enough information where there are multiple options that we create. The person of orders will say, well, I don't know what exactly we mean by engine. What is the meaning of engine? Turbo engine, gas engine, fossil fuel engine, nuclear energy engine, heat energy engine, electrical energy engine. कौन सा engine? I don't know. अगर इतने सब engine होंगे तो इतने उसमें options है 4 wheelers के, उसमें से 3 wheelers ही कितने हैं? और mathematics, if the number of variables I know and if I know the variability in each of the variables, let's say 10 variable हैं और हर एक variable के लिए 5 variants हैं. So simple math tells us that 10 raised to 5, 10 times 10 times 10 times 10 times 5, more than 50,000 options come out. Now I will give you the resources, I will give you time, I will give you manpower, I will give you money, I will also give you any amount of time you require to complete all those 50,000 experiments. But I want only one guarantee from you. Of those 50,000, I want you to tell me how many of them will give me my 3-wheeler. Some of them will, some of them will not, some of them will almost be there. So I am not definite. In spite of providing enough explanation, enough disclosure, enough details with specifications and examples, this one element of engine, number 2 element in my 7 elements, the scope of it is so wide that I don't know which one will give me the 3-wheeler. So I am not definite. Even if I am providing you or so-called enabling you to do all those 50,000 experiments, still I am not. So that is indefiniteness. I am not definite. A person of ordinary regard is not definite. So if it turns out that one of those 7 elements is indefinite, then that claim cannot be granted to you because your entire claim becomes indefinite. So that is number 6. Novelty, innovation, non-obviousness, anticipation, enablement, and indefiniteness. 7th one, there are secondary considerations, so on and so forth. All of this, ultimately, when you satisfy the examiner is satisfied, and then the examiner in US says yes, it is allowed. Allowed, not banned. Allowed. Same thing you satisfy the Indian panel of examiner. The examiner grants you the claim. What is the difference? It is the simple way to understand the difference is you guys are kids, I mean for students. Because you know always what you speak. Although I am a teenager by the way. Birthday is 29th February, so every 4 years I will come here. So I am still I could have populated that, but could not do it. Anyway, so now what happens is, let's say you are admitted to law school here. You go to your parents and say, well, every month I need 50,000 rupees as my expense. Your dad says the homework towards the particular thing. Why? 10,000 is for tuition, granted. 5,000 is for my hostel expense. room and board granted. 25,000 में क्या करोगे? Oh, you know, I have a boyfriend or a girlfriend and every other weekend I have to go for an entertainment. उसके लिए 15,000 लगेगी. This is a probably provided you have the right person. Law school इतना tough है. Ashwini gives me so much homework. Teaches 6 courses. Every weekend I have to kind of wind down. Relax a little bit, I have to go to a club or property. Mind को पूरा chill होना चाहिए. उसके लिए 5,000 चाहिए. 50,000 not allowed. 5,000 not allowed. तो क्या करोगे? Negotiate. Okay. 7,500 are allowed for your non-academic expenses. Not granted, allowed. So there is a provision that there is a basis on which those 50,000 rupees were given to you. Now let's say हो गए negotiation सीधे हो गए आ गए यहाँ month 1 15,000 मिल गए month 2 10,000 आ गए. First thing you pick up the phone, WhatsApp message. Mom, 15,000 दिए पर 10,000 क्या है? Negotiation में 15,000 मिले बोले थे 10,000 मिले. So then, on what basis are you saying that? Because there is a requirement which was allowed. You are allowed 15, so you are entitled for 15. The moment you spend 20,000, the call will come from there also. 15,000 दिए तो भाई 20,000 कैसे next time 5,000 कम करेंगे? No, because there is a deal which is legally binding in terms of US Patent Office. The patent examiner has to give in writing on what basis this claim was allowed. Indian Patent Office में there is nothing. So that's why when I say that when I challenge the US patent for invalidity and my invalidation is based on ये 10,000 15,000 का चक्कर and I say that well 15,000 was allowed and on one of those 7 counts I can prove invalidity, it will not send it to court. Court will say that well there is patent was allowed based on this particular reason. And you are basically challenging this reason, so you have to take it up to the patent office. You cannot come to us, it will still be granted. So what the Indian Patent Office में अगर challenge Indian claim, patent claim, there is no legal binding. Another important difference is आप किसी को भी इंडियन पैटेंट इनको मिला है वो पूछो कि can you give me your copy of your patent? They will provide you one page certificate. One page certificate they provide. ये मेरा granted है. इसमें title of the invention है. So then you ask what is exactly your invention or claim? Explaining solution. I said, no, I don't want explanation. I want to know what is your invention. Take this. Now, when you ask a US patent holder or Europe patent holder, along with that certification which has the seal, they have a copy of the approved manuscript which gets published as a patent, which is different than what you started off with as an application. तो हमारे में प्रॉब्लम क्या होता है कि I have granted so-called claim which is in my one-page certificate, but I ask them to give me your invention, they give explanation, which is your patent application. Patent application is not a patent. US patent application number मिलता है. You can stake a claim of your invention on that. But till it is allowed it is not valid. Because it keeps on changing. So when office actions happen, reviewer and the examiner and the inventor negotiation of that. You keep on revising your claim to get to the final thing. That is allowed. यहाँ भी वैसे होता है. So, but there is nothing, no single document will tell that this is my invention. No problem with that. Today, when I challenge the Indian government, which I have been challenged for many places and they have lost within the IPO because we clearly don't know what exactly is the invention. And the criteria also in India, there are 3, but worldwide there are 7. This is not, I don't take this please as criticism. This is reality. This is what happens. And the last point, before we start to really, I want you to ask questions and explaining you also all of this requires an invention. What is the definition of a patent? A patent is an official document, legal document. Marriage license legal, travel license legal, occupation certificate legal. Official document granting the right to make use of cell to the inventor for a term of years. That this legal definition was written prior to so-called normalization. Because earlier it was 17 years in some countries, 20 years in some countries, date of filing, date of approval or date of grant, all those confusions were there. So now it is all streamlined for a term of 20 years from the date you file. It is not common for worldwide. The only right to make, use or sell is or invention. That is the definition, legal definition. So invention is a prerequisite to get this official document to gain exclusive rights for 20 years. So do we know what is an invention? Do we know what is an invention? People come to us and tell us that oh, आपने मास्टर्स किया है, आपका प्रोजेक्ट किया है, और हम बताएंगे आपको इसकी इन्वेंशन है. You are the one who has created this intellectual property. You should be the one to tell this is what is an invention. Number 1. Number 2, what is the practice? We engage a patent agent, we engage a patent lawyer, we engage a law office. ये मेरा research का analysis है. Patent agent charges in India 60,000 rupees. 2 महीने के बाद come and say ये आपका invention है. हमने oh really? Should be the reverse. They have to tell this is my invention. I need a application which you can help draft because it has valid legal writing. वैसा होना चाहिए. Number 1. Number 2 is how to know that you have an invention. I don't want to be someone going to a barber shop and saying that this is my head, give me a haircut. Up to you. Oh, अच्छा बस कट आ गया कि आयुष्मान पुराना जैसे है तो हमको तो वापस ही नहीं बचेगा. That is the problem. We should be the ones to tell that well, this is my invention. How do we do that? Number 1 is whenever you do a project, whether it is a law project, it is science project, physics project, chemistry project, pharma project, medicinal project, any project you do, what do? You ensure that you go to the literature first, and identify what is not done, or identify that there is a problem that exists, which has not been solved or which needs a solution. Correct? That's what you do. That is the first research you do. I identify a problem, then I do my set of analysis of that. I do a design of experiments, then I conduct the experiments, I collect data, analyze data, and come up with conclusions. That is my first research. Those conclusions have solved the problem. You have done a good job. That is IP. That is only IP. Now, the first research के बाद IP मिल गया. I have solved the problem. I have done some worthwhile work. Now I will go and ask you to do a second search, research, a second time search. In your first providing a solution to a problem, you have come up with, let's say, 20 conclusions. Now I am going to ask you to go back into the literature and say that, well, what is all available in the literature which is similar to what you have done?